Welcome back, y'all. I am the loud little ducky, and today we are going to start getting ourselves up to date in everything that's happening with Laura Owens. So we're starting off with Owens, the Echard, and Gingras and Owens trying to win an appeal at the Arizona Supreme Court. And will David Gingras learn anything from his last appeal and the two losses he had there, which ended up costing his clients more money? She had money that she owed, almost $150,000 in the original Owens v. Echard. Then she added on top of it for the first appeal and then the second appeal. And so now he's taking it to the Arizona Supreme Court, and it might not stop here if he loses this appeal, which could end up costing more money, because he said he will take it all the way up to the United States Supreme Court if they were to take it. But we know that Gingras is tired of losing and he wants to win. Next video, we will be going over Clayton Echard's response. And so let's get this show on the road. So we have in the Arizona Supreme Court, Owens v. Echard, the Court of Appeals, Division II, Maricopa County Superior Court, and petition for review from Gingras Law. They've got the table of contents, which is there's an introduction, issues for review, material facts, reasons why review should be granted, which is number 1, no published Arizona decision controls. 2, the case involves important questions of law which were incorrectly decided. 3, the lower courts misapplied Arizona law. And then apparently a number 3 as, again, conclusion. And so I guess we will see how this goes. Now, this is filed on May 29th, 2025. He did ask for a extension of time on May 13th, 2025, and it was granted. So yeah, he filed this, and then he's got his table of authorities, which are cases that he cites in this, and rules and statutes, which we have become familiar with throughout this case. So jumping in, introduction. From 2006 until 2019, sanctions in family court were controlled by Rule 31 of the Rules of Family Law Procedure. Rule 31 prohibited groundless pleadings. It allowed courts to sanction violators. The rule had no prerequisites before sanctions could be imposed. No warning was required, and once a violation occurred, that was it. The violator could not escape sanctions by withdrawing the offending pleading. Rule 31 was simple, clear, and harsh. It was also old and outdated. Maybe so. Maybe so. But that's his key to saying if we were still under that, then Owens, everything that he is contesting would be fine. But since they're not under that anymore, Owens has a right to get out without sanctions and stuff like that. To keep up with modern standards, in 2018, this court abolished Rule 31 and replaced it with something new, Rule 26. Gotta love Rule 26. Like Rule 31, Rule 26 still prohibits groundless pleadings. But unlike Rule 31, Rule 26 contains new procedural safeguards which must be met before sanctions can be imposed or even requested. That brings us to the heart of the problem in this case. Petitioner Laura Owens, Laura, was sanctioned $150,000 for filing a pleading in violation of Rule 26. But the court followed none of the mandatory safeguards of Rule 26. Instead, the trial court utterly ignored Rule 26. Instead, in substance, the court followed the old abrogated standards of Rule 31. The error was clear, plain, and erroneous. The thing is nobody did anything in a ruling, and the reason that she got sanctioned $150,000, she didn't make a ruling on old Rule 31, and she didn't make a ruling of Rule 26 because it was withdrawn. So it's the same shit we always see with Gingras. He has not learned his lesson, and he is going to die on Rule 26 Hill. And it's not a good place to die because your career is going to be dead if it wasn't already. But let's continue. The court has never interpreted Rule 26. The time has come to do so. This case presents a perfect opportunity for the court to provide clear guidance on this important new rule. In doing so, this court can help all Arizona family courts and lawyers understand change may be hard, but sometimes it's necessary. The thing is, Gingras, the only person that seems to be confused by Rule 26 is you and your client because she's listening to you. But okay. I mean, us lay people, non-lawyers, even understand Rule 26. Issues decided by the Court of Appeals and presented for Supreme Court review. Issue 1. Can a family court impose $150,000 in sanctions for a violation of Family Law Rule 26, the family court equivalent of Civil Procedure Rule 11, without following any of the mandatory safeguards in Rule 26C, prohibiting sanctions unless the moving party first personally meets and confers, followed by a written warning and a 10-day period within which the opposing party may withdraw or appropriately correct the alleged violation? Okay, so he's asking a question here. And before he wasn't asking questions, he was just saying, you can't do this. Issue 2. If a party is threatened with sanctions for violating Family Law Rule 26, and if the alleged violator responds by invoking the safe harbor of that rule by moving to dismiss the offending pleading with prejudice, can the family court refuse to allow the pleading to be withdrawn and then impose $150,000 in sanctions for fees incurred after the violator moved to dismiss the pleading with prejudice? In other words, when a party is accused of filing a pleading that violates Rule 26, can a family court block that party from invoking the safe harbor and then sanction them for the same pleading they attempted to withdraw? She got sanctioned for her behavior in this case, which had nothing to do with the filing itself. It had to do with her actions of lying on the stand, refusing to submit discovery and disclose proper information when the court ordered her to. She didn't get sanctioned for filing this pleading. Now, did the judge think it was frivolous? Yeah. But she didn't do that. She did it because of her behavior during the case, her conduct in the case. Issue 3. If a party is accused of filing a pleading in violation of Family Law Rule 26, but the procedural requirements of Rule 26 are not followed, can the trial court fix the defect by using other authority, such as ARS 25-324 and or ARS 25-809G, to punish the same Rule 26 violation in a manner that does not comply with the safeguards of Rule 26? In other words, Does Rule 26 provide the exclusive remedy for a violation of Rule 26? Or can a court ignore requirements of Rule 26 and impose sanctions under other authority for the same violation of Rule 26? Well, I'm glad he's asking questions, I will say, because whereas before he was just saying, this is what it is, this is how it is, this is how it reads, everybody's wrong, and all these appeals courts and everybody are going to see it my way in the end. Here, he is asking the questions of, is this proper? Which allows the Court of Appeals to answer yes or no on each of these issues. And then that will either tell Gingras that everybody else has been right and he has been wrong, or Gingras has been right this entire time and he's going to rub it in everybody's faces because everybody else was wrong and he was right. So by asking questions, hopefully that gives him some clarification in how this is. But even if they say, no, you're wrong, she can sanction this way. He's then going to move possibly to the United States Supreme Court and then kind of do the same thing and hope that the United States Supreme Court clears it up and that he will be proven right eventually. Or he's finally going to be told what everybody else has been telling him and he could have saved money on. So we will see how all this goes down. Issue 4. Can a family court award $150,000 in fees under ARS 25324 or ARS 25809G without making a specific factual finding that a party's unreasonable conduct caused the other party to necessarily incur reasonable fees? She made findings. They had to call up all these medical facilities. They had to file tons and tons of motions and pleadings and things like that because of her behavior in this case. And it would have saved everybody a lot of time and money if she would have just fessed up. And now with her criminal case, is she going to finally fess up or is she going to double down, triple down? Issue 5. When a trial judge considers ex parte evidence such as an anonymous social media post made after a hearing, which are not admitted in evidence, and the court makes an adverse factual finding based solely on the extrajudicial evidence, is the judge obligated to recuse, and if recusal is denied, is the subject to harmless error review, which requires a separate showing of actual prejudice, or is it a structural error requiring automatic reversal without any further proof of prejudice? Once again, he's asking the question and not just stating it as fact. So I do like this question way better. I don't know if that's just how it has to be for Arizona Supreme Court review or something else. But it'll be interesting to see because I do like this way, asking the questions that he wants to know and so that he can get clear answers on it. And then everybody can know. And it's hopefully is written in black and white and everybody can read it. Material facts. The first dispositive issue is purely a question of law. Did the trial court apply the wrong legal standard when it ordered Laura to pay $150,000 in sanctions for filing a pleading that violated Rule 26 without following any of the procedural requirements of Rule 26? Resolving this question of law involves no factual disputes, even if every adverse finding of fact against Laura is true, lower courts still erred as a matter of law because they misapplied Rule 26. So here he's going to state the things that we hate because it's his point of view. This court has never interpreted the Rule 26 safe harbor, but countless federal courts have done so with its federal counterpart. Decades ago in 1993, a federal civil Rule 11 was amended to add safe harbor exactly like the one in Rule 26. In ensuing 32 years, federal courts have consistently held if the safeguards of Rule 11 are not followed, sanctions are unavailable. This is true even if the underlying pleading was frivolous. See Holgate v. Baldwin, which, if you didn't watch on Reality Steve's YouTube channel, podcast, whatever, of Rachel Juarez and him and Gingras all talking about this, then you missed out and you should go watch it because it is really good and it explains why Gingras is wrong. He said, we must reverse the award of sanctions when the challenging party failed to comply with the safe harbor provisions, even when the underlying filing is frivolous. Arizona trial courts concur that Rule 11 sanctions are not available to a party that fails to strictly comply with the requirements of the safe harbor provision. Gallagher v. Serrano, Law Offices, 2020, Arizona Supreme or Superior, I don't know, super, whatever. Yeah, it's a Superior Court case, and he has the link for it. Footnote 1, unpublished authority cited for persuasive value only. So it's not even a published citation. Because the error was procedural/legal, the facts are essentially irrelevant to the question of Rule 26 application. However, some background detail is helpful for context. As such, a condensed summary of the facts is offered. Number 1, background. A 2-hour evidentiary hearing was held on June 10, 2024. The transcript is provided in the petitioner's appendix as Exhibit B. The basic facts come from the transcript. Laura claimed in May 2023 she had a one-night sexual encounter with respondent Clayton Echard. 11 days later, Laura took a test that showed she was pregnant. Clayton denied sexual intercourse occurred, but he initially acknowledged in writing that there was sufficient other sexual contact that pregnancy was a possibility. Months after the case began, with both parties proceeding pro se, in mid-December 2023, Clayton retained counsel who accused Laura of fabricating the pregnancy. Clayton's counsel threatened to seek sanctions under Rule 26. I'm glad he's just calling it a sexual encounter and not the other thing. Days later, Laura retained counsel, and on December 28, 2023, Laura invoked the Rule 26 safe harbor by moving to dismiss with prejudice. He made sure he underlined that because it was something that the other appeals court said without prejudice, and that was not the ruling. It was with prejudice. But in their opinion, it didn't matter whether it was with or without. And he gives that in his appendix, Exhibit C. In her motion, Laura explained petitioner is not now pregnant with respondent's children. Here, there is no paternity or maternity to establish as petitioner is no longer pregnant. Accordingly, this case must be dismissed, he says. Despite Laura invoking Rule 26 safe harbor, 6 days later on January 3, 2024, Clayton moved for sanctions under Rule 26, Exhibit D. The motion cited no other authority other than Rule 26 as grounds for sanctions. Clayton's, yes, it did. Maybe not that particular one, but his original ones did have it. And they were in all the other ones as well. We've gone over that. Clayton's motion failed to comply with Rule 26 new procedural requirements in multiple ways. First, Clayton failed to provide the written warning required by Rule 26C2B. Second, Clayton failed to attach the copy of a written warning to his motion as required by Rule 26C3D because no such warning was given. Third, Clayton filed the motion before the 10 business day safe harbor period required by Rule 26C2B lapsed. Fourth, Clayton filed the motion despite Laura promptly doing exactly what the safe harbor permitted. She withdrew the alleged violation. The trial court found Laura's petition violated Rule 26. What? When was that found? Nobody said that Laura's petition violated Rule 26. Despite this, the court held compliance with safeguards. Where is that? If somebody has where the court found that Laura's petition violated Rule 26, I would like to see it because I don't remember that part. Safeguards of Rule 26 was not necessary because fees/sanctions can be ordered under other authorities. Example, ARS 24324 and or 25809G. And those other authorities do not have the same safeguards as Rule 26. The Court of Appeals affirmed that logic. Exhibit A. It might have been in the final ruling that maybe she said, I could find, I do believe she violated Rule 26, but she could have violated Rule 26, but I'm not going to have findings under that because that was withdrawn. So I am having findings of this, and this under ARS 24324 and 25809G, and she didn't issue findings under Rule 26. That may be where she did it. And to me, if that's where he's saying that the court found Owens' petition violated Rule 26, then to me it's still not a big deal because she didn't sanction her under any of that. And to me, for this to be a thing, she would have to be sanctioned under that rule, and she wasn't. So all this talk about Rule 26 is ridiculous. Thankfully, it's not like 20 pages of talks about Rule 26. Now getting into number 2, additional facts relevant to structural error. So a lot of this stuff, when we had the original appeal, was like twice, if not triple, the amount of pages as this. This is more condensed down, which I appreciate because having to listen to him drone on and on about things is not great for anybody. But he says, after receiving the trial court's post-hearing ruling, Laura noticed a key factual finding was not based on any evidence admitted at trial. Rather, the finding appeared to have been copied from a social media post made by an anonymous third party on the internet after the trial concluded. Specifically, in summarizing the trial testimony of Clayton's medical expert, Dr. Samantha Deans, this court made the following findings. She, Dr. Deans, testified that Planned Parenthood does not accept anonymous patients, which they don't. They do not accept patients using an alias. Patients are required to provide a government-issued form of identification, which they do. She further testified that Planned Parenthood is not open on Sundays when petitioner testified she sought care on July 2nd, 2023. And he underlined that last statement that we just read because that's the one he said Dr. Deans didn't say at trial. Now, we do not have the entire medical opinion from Clayton Echard's expert Dr. Samantha Deans. We only got snippets from Gingras, and so I don't know if in that it does talk about that or not. And then he says Exhibit E, the specific finding that Planned Parenthood is not open on Sundays was attributed to the trial testimony of Dr. Deans. But as the trial transcript, Exhibit B clearly shows Dr. Deans said no such thing. Instead, it appears the only basis for the court's finding was anonymous social media posts published online after the trial concluded. Exhibit F. Upon seeing this, Laura filed a notice for change of judge for cause, arguing the trial judge's review and consideration of extrajudicial evidence. Social media posts published on the internet after the evidentiary hearing was sufficient to show the bias and prejudice within the meaning of ARS 124095. The presiding judge denied Laura's notice, concluding with essentially no explanation that these facts failed to show by preponderance of the evidence that Judge Mata's finding that Planned Parenthood is not open on Sundays reflects bias or prejudice against the petitioner. The presiding judge also found any misconduct was non-prejudicial because the issue of Planned Parenthood's business hours was of little to no importance given the rest of the findings in the July 17th ruling, Petitioner's Appendix Exhibit G. Those findings were affirmed by the Court of Appeals, which rejected Laura's argument that the judge's review of extrajudicial evidence constituted structural error requiring an automatic reversal. The court further observed, while a trial court's reliance on extrajudicial information may give rise to a claim of judicial bias apart from any structural error claim, the critical inquiry that would require reversal is whether the conduct demonstrates an extrajudicial source of bias or a deep-seated favoritism. The appellate court concluded that Laura failed to meet the standard and that the issue of Planned Parenthood's business hours was not prejudicial. And I will link in the description box for any of you who have not seen it. You can find it on the Owens v. Echard playlist, but I will also link it in the description box of why I, think Judge Mata had the right to run across some comment that said Planned Parenthood wasn't open, but also the thing is if Judge Mata looked up the hours or saw a social media post, he cannot prove that it was to be biased against Laura. Because what if she was doing it to confirm something that Laura might have actually been telling the truth for this, and that would give some more concrete evidence as to she's being truthful about this scenario. He cannot prove that because she ran across something that showed that Planned Parenthood was closed on Sunday there, that it was so that she could prove that Owens is in fact a liar, pants on fire. And really, it's not the whole point of this case. Because that's one thing. You take the hours of Planned Parenthood away, the case is still the same. The case is still Owens not being pregnant and lying about it. It's still she didn't turn over discovery. She did not give the information about Los Angeles Planned Parenthood. She sent people on a fishing expedition to places she knew that her information wasn't at. She lied about having doctor's appointments. So even without the hours, this case doesn't change. And that's why it is considered a harmless error. Taking that piece of furniture out of the house does not change the structure and make the whole house of cards fall down. Difference between structural and harmless error. But let's continue on. In reaching these conclusions, as explained infra, the Court of Appeals misapplied Arizona law, and it made the same legal error that was reversed by the Kentucky Supreme Court in Marchese v. Abersold, which I believe we've gone over that case before, and that one doesn't really apply here either, even though he says it does. Finding review of extrajudicial evidence in family law matter constituted structural error, requiring automatic reversal without any showing of prejudice required, and reversing Court of Appeals decision, which held harmless error review applied. So then he jumps into something else. Reasons why review should be granted. Number one, no published Arizona decision controls this point of law. Rule 26, oh dear God, we're back here, is essentially brand new in family court. On August 30th, 2018, this court ordered sweeping changes to the rules of family law procedure, see R170054. This was the first overhaul since the family law rules were created in 2006. This change was so significant, Respondents' Counsel even shared a helpful article about it, observing the update was needed to confirm those rules to modern usage. And then he links. And to quote and give a screenshot and a citation from Woodnick Law. The balls and the audacity of Gingras to be like, see, Woodnick Law even says the same things as me. So I don't know why they're going to even respond to this and not just say I'm right, because even the law firm says exactly what I say, which I bet it doesn't. But let's see what this says. So, Woodnick Law has an article, Revisions to Family Law Rules. It is by the Honorable Rebecca Birch, who is retired, and Mark Meltzer. And it was published in Arizona Attorney, January 2019, at 20. Okay, I don't know what at 20 means. But it says, during the past several years, the Arizona Supreme Court has adopted restyled rules of evidence, civil appellate procedure, protective order procedure, civil procedure, and criminal procedure. In December 2016, Chief Justice Scott Bales directed a task force to review the current family law rules to identify possible changes that would confirm those rules to modern usage and to adopt a new set of family law rules. Okay, so that's where he got that quote from. On August 30th, 2018, the Supreme Court approved revisions to the Arizona Rules of Family Law procedure. The new rules apply to all cases filed on or after January 1st, 2019, and to all cases pending on that date unless their application would be inequitable or unjust. The new rules are completely restyled, modestly rearranged, and occasionally changed substantially. Most of all, comments have been eliminated. Okay, and then he gives his citing, which says, as the original article notes, the purpose of the change was to conform the rules to modern usage, and gives the rest of that citation. Okay. All right. I don't know how any of that proves your point, but go on with yourself. When it changed the rules 6 years ago, this court fundamentally altered the process for seeking and avoiding sanctions in family court. Unfortunately, because Rule 26 is so new and because it contains requirements not present in old rule it replaced, there is no published authority from this court or from the Court of Appeals interpreting the safe harbor requirements of Rule 26. That lack of guidance allowed the lower courts, in this case, to severely misunderstand and misconstrue the new rule. Or you, the one misunderstanding and misconstruing the new rule. And they think they're pretty clear on it. This court has never spoken on the issue of Rule 26 safe harbor. It should do so now. The public, lawyers, and courts deserve clear, authoritative guidance from this court explaining exactly how Rule 26 works. The fact that standing alone warrants this court's review. You know, when we get warning labels on things and you're like, who was the idiot that required this? Gingras is the idiot that required that warning label in the law. Yeah, he's one of those. Because they're going to be like, okay, but isn't that what the rule already says? They're just writing it different. Okay. All right. All right. Then he goes to 2. This case involves important questions of law which were incorrectly decided. That is your opinion, Gingras. The lack of any published authority involving an important new rule is a reason enough to grant review. But another good reason exists. The Court of Appeals decision was egregiously wrong. The Court of Appeals blatantly ignored more than 30 years worth of federal case law, interpreting the now substantially identical federal version of Rule 11, which Rule 26 was expressly modeled after. Indeed, the Court of Appeals refused to even discuss any of the federal authorities supporting Laura's position, concluding, wrongly, that it was not well grounded in fact or law. That's everybody's opinion, not just theirs. Clearly, the opposite is true. Apparently, it's not that clear, because you're the only one that thinks this way. Indeed, the Court of Appeals errantly affirmed using the logic and process of the outdated and now abrogated Rule 31. The error was directly invited by Clayton, who improperly cited outdated Rule 31. Authorities such as Grow v. Grow, which is appellate 2018, a case decided before the 2019 rule change. Grow involved Rule 31, not Rule 26. Because of that invited error, the Court of Appeals improperly ignored helpful and plentiful federal cases interpreting aspects of Rule 11, which are functionally identical to Rule 26. In refusing to accept guidance from the federal courts, the appellate court also departed from Arizona's long-standing tradition of doing exactly that. See James Cook Hobson Incorporated versus Lake Havasu Plumbing and Fire Protection, which is an appellate 1994 case. Arizona courts consider federal court interpretation of Rule 11. To help shed light on Rule 26 function, in her appellate briefing, Laura cited extensive federal case law, describing several key aspects of Rule 11's purpose and application. First, when the procedural requirement of Rule 11 are not followed, sanctions cannot be awarded even when the pleading violates the rule. We must reverse the award of sanctions when the challenging party failed to comply with the safe harbor provisions, even when the underlying filing is frivolous. Holgate. Also, Westerkamp v. Mueller, 2023, Arizona, denying sanctions when procedural requirements of the rules are not met. The thing is Rule 26 was not on the table, Gingras. So here you are droning on about Rule 26, and this is why the Court of Appeals didn't even give a shit about your first appeal. And they didn't care to deal with the second one. Because nothing in this case was based on Rule 26 after it was withdrew. Why can you not get this through your thick skull? Maybe after they give you a black and white, you're wrong about this. Maybe it will sink into your skull. But I doubt it. Because you can't ever admit wrongdoings in this case. Second, when the procedural requirements are not met, a court cannot sua sponte fix the error by converting a defective Rule 11 motion to one made under some other authority, such as the court's inherent authority. This is not permitted because doing so would destroy the safe harbor's purpose. See Ratcliffe v. Rainbow Construction Co. 9th Circuit 2001. This is another one that Rachel Juarez, Reality Steve, and Gingras all dealt with on that podcast that you need to go see. Rejecting this approach and explaining it would render Rule 11C1A's safe harbor provision meaningless to permit a party's noncompliance motion to be converted automatically into a counter-initiated motion, thereby escaping the service requirement. Similarly, because of the point, the safe harbor is to encourage litigants to withdraw claims without fear of sanctions. A party cannot seek sanctions after a litigation has timely offered to dismiss this case with prejudice. Doing so completely ignores the purpose and requirements of the safe harbor provision. Corner Edge Interactive LLC versus Johnson 2021, Arizona. Third, Laura cited extensive authority holding when a party threatens Rule 11/26 sanctions, as occurred here. The accused violator has an absolute right to withdraw the offending pleading before punishment can be imposed. If corrective action is timely taken, as it was here, sanctions cannot be ordered. Barber v. Miller. 9th Circuit, 1998. Reversing sanctions where alleged violator was not given the opportunity to respond to the sanction motion by withdrawing his claim, thereby protecting himself totally from sanctions pursuant to the motion. The purpose of the 1993 amendment was entirely defeated. An award of sanctions cannot be upheld under those circumstances, emphasis added. To the extent Clayton cited any responsive authority at all, it only further supported Laura's position. For instance, Clayton cited dicta from whatever that is, 8th Circuit 2024, which implied but did not decide that sanctions for groundless pleading might be available under other authority, even if Rules 11 safeguards were not met. But in that case, involved an award of $50,000 in sanctions imposed after the alleged violation was resolved by dismissal of the complainant. Rather than affirming the sanctions on alternative grounds, as Clayton specifically argued was proper, the appellate court reversed the award of sanctions. It did so because in the context where sanctions were requested after a violation was cured, the violator was not afforded an opportunity to remedy the sanctionable conduct and avoid the sanction. And he cites the case again. The exact same error is present here. The trial court imposed $150,000 in sanctions for fees which Clayton incurred after Laura invoked the safe harbor by allowing the case to continue for 6 months beyond that point. The trial court deprived Laura of her absolute right to safe harbor. The court's machinations and disregarded this court's final rulemaking authority when it abrogated, I am not good with that word, Rule 31, which would have permitted this outcome, whereas Rule 26 plainly prohibits it. Okay, whatever you say. The fact that fees/sanctions could have hypothetically been awarded under other authority does not change the result. Here, Clayton actually threatened Laura with Rule 26 sanctions. Then he actually moved for sanctions under Rule 26. Those are facts, not hypotheticals. And then what you left out is then Clayton revoked, withdrew, took away the request for sanctions under Rule 26. He forgets that part. Applying Rule 26 correctly, the moment Clayton threatened sanctions, the rule gave Laura the absolute right to withdraw her petition within 10 business days, which she did, thereby expeditiously terminating the proceeding, or at least trying to. This result was required to promote the central purpose of Rule 26, see Lake v. Gates, which is a 9th Circuit 2025 case. The central purpose of Rule 11 is to streamline the administration and procedure of the federal courts. By refusing to allow Laura to take the safe harbor, the trial court did exactly the opposite of what Rule 26 was adopted to achieve. The court needlessly forced the parties to spend 6 additional months litigating a moot issue. When Laura told the court she was no longer pregnant, the issue of paternity clearly became moot. Of course, Clayton argued he still had a claim for fees, but Clayton was pro se and incurred no fees, or at least not $150,000 in fees. From the commencement of the case until the time Laura moved to dismiss. To the extent Clayton incurred any fees meeting and conferring with Laura's counsel about the issue of sanctions before Laura moved to dismiss, those fees were precluded by the effort of the safe harbor. A party who takes the safe harbor is rewarded with safety from sanctions. And I wish there wasn't a safe harbor. Like, stop filing frivolous shit. How about that? Go back to the old rule where you do not get out of it. You wanted to do this? Let's go. Oh, you don't like it anymore? Too bad. I like that rule. You get to get out by ruining people. Get the hell out of here. 3. The lower court misapplied Arizona law regarding judicial misconduct. Although it is not necessary for this court to reach the separate question, the Court of Appeals also improperly decided a separate issue of law involving judicial misconduct. As noted above, the trial judge made a key adverse finding regarding the business hours of Planned Parenthood, but that finding was not supported by any evidence admitted at trial. Instead, this finding was clearly copied from social media posts made on the internet after the June 10th evidentiary hearing concluded. The Court of Appeals held in this context, harmless error review applies rather than the stricter rule of structural error. Exactly the same thing happened in Marchese v. Abersold, Kentucky 2017. No, it is not the exact same thing, but okay. A case involving a family court proceeding in which the trial judge considered extrajudicial evidence regarding the criminal history of a party. Yeah, business hours for Planned Parenthood and somebody's criminal history are not the same. And somebody's criminal history has a lot to do with a deciding point. Planned Parenthood being closed on Sunday has nothing to do with anything, except for it's an extra thing that showed your client is a liar, liar, pants on fire. Involving a review of ex parte evidentiary is subject to harmless error review requiring proof of prejudice. Just as this court should do, the Kentucky Supreme Court granted review and reversed holding, saying we conclude the trial judge's undertaking to obtain and use evidence extrajudicial information relating to a party in the case caused her disqualification from proceeding further as the presiding judge in this matter. Her failure to recuse at that point was the structural error, undermining the integrity of the resulting DBO because structural error is what I'm going to guess. But it says because structural. What do you know? It says error supersedes harmless error review. We need not review the findings of the Court of Appeals. That the error was harmless and cites the case again. Here, without any decision of Court of Appeals, rejected the Kentucky Supreme Court's holding in Marchese. In doing so, the court also misapplied Arizona case law, which reached the same result as that case. See State v. Emmanuel, which is an appellate from 1989, holding when a trial judge conducted ex parte interviews of victims in a theft case, judge was required to recuse, and defendant was entitled to resentencing before a different judge without any showing of prejudice. Yeah, that one's not the same as this at all. That is not good. Like, you cannot do that. Like, you cannot have ex parte communications with anybody, even though Owens tries to do it with the judges all the time. Conclusion. The word limit of the Rule 23 do not provide room for a complete discussion of all other issues, but for the reasons stated above, this court should grant a review of this exceptionally important case. The court should further order supplemental briefing and oral arguments and should reverse the judgment below. Dated May 29th, 2025, signed by Gingras. He's requesting fees for this. Good luck with that. I don't think that's going to happen for you. And then he has the appendix. And now I want to look at a part in the transcript from that June 10th hearing. So let's review that. Okay, so I want to concentrate on this part here. And this is what the court says at the end of the trial on June 10th. This is not easy to do on a computer. But she says, okay, so at this time, what the court's going to do is I'll take this under advisement. What that means is I'm going to go back. I'm going to review the notes that I took today. I'm going to review the evidence that was admitted to the court, and then everyone will receive my order in writing. Now, my question for this is the evidence just the exhibits that were admitted into that June 10th hearing? Or is it things that were also in the motions that were filed? Is that considered part of the evidence and things like that? That's what I would like to know is, and I also don't know what Dr. Deans wrote, since we didn't know about Los Angeles Planned Parenthood and it at all. We knew of like other areas like Orange County and San Bernardino, California. I don't know that Dr. Deans would have said anything about Los Angeles unless it's just flat all California Planned Parenthoods are not open on Sunday. But, and is evidence just what was submitted on June 10th, because that was just an evidentiary hearing, not a trial. It's just an evidentiary hearing. Does Judge Mata get to review all of the motions and everything else? And if she does, Gingras's blog and his website was a citation in a motion. And so anybody that was on his blog that said anything about Planned Parenthood being closed on Sunday, Judge Mata could have gotten it from there. But that's my biggest question. I thought she said she was going to review everything in this case, but she was going to review the notes that she took today, and she was going to review the evidence that was admitted to the court. So, and she's taking it all under advisement. So I don't know what that necessarily would include or not include, but that would be my question, is what does the review and under advisement entail in making a decision on this case? Because it's not just a decision on what happened on June 10th. It's a decision on the entire case. So I think what is in these motions and what is put into and submitted to the court through these motions is also considered evidence. But let me know what you think in the comments, and I will see you in the next one for Clayton Echard and his response to this motion. Bye.